Welcome to EU Privacy for All, Session 48 on GDPR, Article 60, Cooperation between Supervisory Authorities, the one-stop-shop mechanism. Article 60 on the cooperation between the lead supervisory authority and other supervisory authorities concerned lays down that the lead supervisory authority shall cooperate with the other supervisory authorities concerned in an endeavour to reach consensus. The lead and the authorities concerned shall exchange all relevant information with each other. The lead may request at any time other supervisory authorities concerned to provide mutual assistance and conduct joint operations, in particular for carrying out investigations or for monitoring the implementation of a measure concerning controller or processor established in another member state. The lead shall, without delay, communicate the relevant information on the matter to the other supervisory authorities concerned, and once again, without delay, submit a draft decision to the other authorities concerned for their opinion and take due account of their views. Where any of the other authorities concerned, within a period of 4 weeks after having been consulted, expresses a relevant and reasoned objection, if it does not follow the relevant and reasoned objection, the lead will have to submit the matter to the consistency mechanism. Where the lead DPA intends to follow the objection made, it shall submit a revised draft decision that will be validated within EDPB in a time frame of 2 weeks. Where none of the other concerned supervisory authorities has objection, the lead supervisory authority and the concerned supervisory authorities shall be deemed to be in agreement. The lead shall adopt and notify the decision to the main establishment or the single establishment of the controller or processor. However, the supervisory authority to which a complaint would have been lodged is the one in charge to inform the complainant on the decision taken by the lead. By derogation, where a complaint is dismissed or rejected, the supervisory authority to which the complaint was lodged shall adopt the decision and notify it to the complainant. Finally, where the lead and the concerned supervisory authorities are in agreement to dismiss or reject parts only of the complaint and to act on other parts of that same complaint, a separate decision shall be adopted for each of those parts of the matter. The lead shall adopt the decision for the part concerning actions that will be followed up by enforcement potentially, while the supervisory authority of the complainant shall adopt the decision for the part concerning dismissal. Finally, the controller or processor shall take the necessary measures to ensure compliance with the decision and shall notify the measures taken for complying with the decision to the lead supervisory authority. Urgency procedure could be implemented in certain cases, and the lead and other concerned supervisory authorities could interact and exchange using electronic means and a standardized format. Several key recitals are to be paid attention to. Recital 127 spots the fact that each supervisory authority not acting as lead should be competent to handle local cases. For example, in the employment sector, whenever there is a processing tackling issues regarding employees' data. The supervisory authority should inform the lead in such case without delay about the matter. After being informed, the lead should decide whether it will handle the case or not. Where the lead decides to handle the case, the supervisory authority which informed it should have the possibility to submit a draft for a decision, and the lead will have the obligation to take utmost account when preparing its final draft decision. In Recital 125, it is set forth that the lead should be competent to adopt binding decisions regarding measures applying the powers conferred by the GDPR. In its capacity as lead, the supervisory authority should closely involve and coordinate the authorities concerned in the decision-making process. Particularly, where the decision is to reject the complaint by the data subject in whole or in part, that decision should be adopted by the supervisory authority with which the complaint has been lodged. In Recital 126, it is announced that the decision should be agreed jointly by the lead and by the authorities concerned. The controller or processor should take the necessary measures to ensure the implementation of the decision notified. Recital 128 lays down that the rules on the lead and the one-stop-shop mechanism should not apply where the processing is carried out by public authorities or private bodies in the public interest. In such cases, the only supervisory authority competent will be the supervisory authority of the member state. In Article 56, on the competence of the lead supervisory authority, it is set forth that the supervisory authority of the main establishment or of the single establishment of the controller or processor shall be competent to act as lead for the cross-border processing carried out by the controller or processor concerned. Article 65(1)(a) states that, regarding the dispute resolution by EDPB, the board shall adopt a binding decision where, in a case referred to in Article 64, a supervisory authority concerned has raised a relevant and reasoned objection to a draft decision of the lead, or the lead has rejected an objection as being not relevant and or not reasoned. In Article 28, the Directive 95/6 states that each supervisory authority is competent, whatever the national applicable law to the processing in question, to exercise on the territory of its own member state the powers conferred by the Directive. The supervisory authorities have an obligation to cooperate with one another to the extent necessary for the performance of their duties, in particular regarding the exchange of useful information. There is no more regarding the one-stop-shop mechanism. What should accountable data controllers and processors get prepared for? Controllers and processors should identify their lead supervisory authority and all concerned supervisory authorities. The lead may request at any time other supervisory authorities concerned to provide mutual assistance, notably regarding joint operations. They shall bear in mind that the lead supervisory authority will be the one drafting the decision. However, a caveat here, it is not the case regarding public bodies. Each concerned supervisory authority might trigger relevant and reasoned objection regarding the draft proposed by the lead. In case of disagreement, the consistency mechanism will be put in place. The lead will notify the decision to the main establishment or single establishment of the controller or processor concerned. Another caveat, the supervisory authority concerned to which a complaint has been lodged will be the one informing the complainant on the decision. A complaint can be partly rejected. The concerned supervisory authority will inform the complainant, and partly validated. The lead will inform the main establishment on this part. Controllers or processors have the obligation to notify the measures taken for complying with the decision to the lead. Each non-lead supervisory authority will handle local cases. So the question triggered now regards the consistent implementation regarding lead and concerned supervisory authorities cooperation.